It seems there is always going to be a need for any professional who is analyzing DNA evidence to get an expert consultation. Would that be fair to say? Particularly as it comes on to the area of the interpretation of the data.
I think I've got a couple of layers of an answer to that observation. Again, let me just point back to this idea that if in a jurisdiction, any kind of methodology, breathalyzer for blood alcohol, DNA, fingerprint. If in a jurisdiction a particular forensic technique has not been very rigorously challenged, that's when you should have the greatest expectation of finding that there are problems with what it is that's being done for that particular test. Um, in a place like New York City, for instance, they have a very robust defense bar. The Legal Aid Society in New York City has some very skilled attorneys as well as scientists on staff. And so as a result, I don't expect to see egregious problems in testing from New York. So, again, in a jurisdiction perhaps like Jamaica, where there hasn't been a lot of rigorous, careful challenge to testing, that may be a warning sign that there's a greater potential for problems. And something that I've been trying to promote for 30 some years is that to make defense attorneys in particular more comfortable with asking to see the data that actually underlies a testing laboratory's conclusions. My focus is on DNA, but I think that's entirely appropriate for any forensic test. Our criminal justice systems allow defendants to confront those who are bringing evidence against them. I don't know how you can do that effectively if you didn't ask to see the data. That doesn't necessarily mean that you have to carefully evaluate the data, but it's entirely fair to just ask. I've actually been talking with an economist about a study that I think would be very interesting in terms of assessing the outcomes of trials where defendants have asked as part of the discovery process to see the underlying data versus where they do not. I'm confident that, that 10 or 15 minutes of work on the part of an attorney to file that discovery motion and ask for those materials that they're entitled to receive would translate into tangibly different outcomes for their clients. Right? I'm certain that would be the case. And that's a simple thing. Just ask for it. Even if you don't look at it, just ask for it. And I think what happens when you ask for it is it serves notice to the testing laboratory. Oh, wait, maybe I need to, play this one a little bit more straight. I can't shoot from the hip. Somebody might be actually holding me accountable for the conclusions that I'm articulating. And then, if you want to take it to the next level, I don't think that's asking much at all, but if you want to take it to the next level, then you could say, hey, I don't have a lot of familiarity with this kind of testing. I don't know what this means. I can't even open these computer files. And that's often going to be the case with DNA test results. And then you could reach out and find somebody like myself who could do that for you. And, literally, for Julian Washington's case, I think it was less than 10 minutes into looking at the testing that was done in his case that I realized that there were some serious problems. And then altogether, maybe another few hours on top of that. It's not a huge enterprise to find an expert, call a friend, and have them take a look. In my experience, I have to appreciate that there's probably a selection bias. I probably get contacted for the cases where the attorneys think something's more fishy than usual, but even still, about a third of the time that I'll look at a lab's test results, I'll simply tell the attorney, it's like, I think this is a good time for you to start talking about a plea bargain, right? Because the test results are totally consistent with the prosecution's theory of the case. But about a third of the time, I'll tell them that, hey, there are some interesting issues here, and if you wanted to, you could ask some questions during discovery or cross-examination that might temper how much weight is attached to these DNA test results. And then, of course, about a third of the time, I'm seeing things that are just like, wow, this is wrong, or hey, these test results are actually more consistent with the defendant's theory of the case. than with the prosecution's theory of the case. And ideally, in those circumstances, I don't have to do anything more. I just have to explain it to the defense attorney, and then they can explain it to their prosecutor, and the prosecutor can talk to the lab. And when all that conversation is done, everybody says, oh, yeah, let's just not talk about the DNA evidence because there's not that much happening here. So again, I don't just ask to see the data that underlies the report. Most labs will generate a 2, 3, maybe a 4-page long report. That was the case in Julian Washington's circumstance. Underneath the data that underlies that are a CD's worth of data, thousands of pages if you were to print it all out. Costs nothing to ask. Maybe it costs 10 or 15 minutes to file a discovery motion, but beyond that, there's no harm in asking. It's certainly not going to make a defendant's position any worse than it would have been if they hadn't asked.
That actually, there was a quote I was reading Actual Innocence, where they're talking about Fred Zane.
Yes.
It said, like, that quote just stuck with me, that they were saying that if one defense attorney had asked in 10 years for the notes, it would have changed everything. So I really think that reiterates the point that you're making. And I think it's actually a very good start.